5 minutes, yes, sir.
Thank you. The sole issue on this appeal is the failure of the trial court to apportion an award of legal fees to the appellee in the amount of $35,661.73. There was two issues that were before the trial court at the hearing at the trial level. It was a motion for modification of child support as well as a petition for civil contempt. It's the position of the appellant that he was the prevailing party in regard to the motion for modification. He would stipulate and agree that the prevailing party in regard to the motion for the petition for civil contempt was the appellee. Tennessee Code Annotated 365103C provides a prevailing party can recover from a non-prevailing party reasonable attorney's fees, and both of these particular matters would have fallen under that particular statute. So the question that I think is before this court is technically who is the prevailing party as it relates to the modification. I think the facts, and the appellant would argue these facts, is that it's clear that he was the prevailing party. He was the victor in that particular case. And the reason is because he filed the modification and he received a modification. His child support was reduced by $236, which was almost half of what he was paying. A total of $20,000 is what the reduction was, compared to what the appellee was asking. The appellee testified that, well, let me go back a little bit. The appellee had actually filed a sworn statement indicating that she believed his oath through a child support worksheet was $2.2 million a year. She later testified at the hearing that she believed that was low, and it was approximately $3.3 million a year. That would have been approximately $184,000 a month, if my math is correct about that. And compare that to what the court ultimately did. The court ultimately found that the annual income of Mr. Wilson was $98,000. So it was significantly different between what the two parties wanted. And to be candid with the court is, I don't know how more victorious a person can be than having that disparity of the income.
Well, wouldn't you have to concede here the appellee had at least a success on a significant issue?
Judge, I don't think it would. I would consider it to be, and I think they argue that they were substantially the prevailing party because he was asking for child support, for her to pay him child support, and he only got a reduction. I don't think that qualifies as a substantially prevailing party when the remedy would have been that she either wanted the, I'm sorry.
Well, no, please go ahead. I want you to finish yours.
The remedy she would have been asking for is either to assess his income somewhere between $2 million and $3 million, or keep the child support amount the same, and neither one of those happens. And I think that gets back to the case law that says you have to prevail on some issue. Right. And I would submit to you that was not a reward or a prevailing party on any of those particular issues.
Our Supreme Court said in Fannin, a prevailing party is one who has succeeded on any significant issue in litigation which achieves some of the benefit sought in bringing suit. I mean, I just see that here the appellee got some victory on their on at least a significant issue. I mean,
I can see the fact is that he wanted more, but you have to sort of make that same argument as it relates to the appellant. He was also successful on a significant issue, and he would have been substantially the prevailing party because he got a very significant change in his child support calculation.
So does it work like that? I didn't think it was binary, that you couldn't have both sides having some significant issue victories, for lack of a better terminology, and you could still choose a prevailing party in that instance. Isn't that?
I think there can only be one prevailing party. I think that only makes sense. Is to have co-prevailing parties would seem to be inappropriate under these circumstances, and I think you have to sort of look beyond just sort of the arguments of what the appellant's saying is. I think you can look at the two court orders that Chancellor Cox issued in this opinion. The first one was after the hearing on these two particular issues, and the court said it is appropriate to award attorney's fees for mother for having to bring this action in contempt. And so the court in its initial order made reference specifically to the contempt action. This was a 9-page very thorough opinion. 8 pages that was dedicated almost exclusively to the modification. And it wasn't until the section dealing with the civil contempt did the court make that finding. In fact, it was under the heading of that. So it would be our position is that the court spoke through its orders and it indicated who the prevailing party was. The court went on a little bit further in its second order, and this is the order on the apportionment is, and the court, and I'm paraphrasing this, the court basically said something to the effect is the conduct of the appellant outweighs the lack of success as it relates to the appellee. And we would submit to you is the court speaks clearly through that and saying is, I never found the appellee to be the prevailing party, but I'm awarding these attorney's fees because of the conduct of the appellant. We disputed that at the hearing. It was disputed at the apportionment portion of this particular case. And we're not really sure sort of where that came from, except for the fact is that the court seemed to indicate that he was unhappy with the appellant as it relates to his answers in discovery, or maybe even the evasiveness that he answered some of the questions about his income. We would submit to you that that was an appropriate way to answer it. As small business owners sometimes do, they rely on their tax preparers and they rely on professionals to provide them that information, and that's what he was doing. More to the point is that I don't think you can hold a litigant accountable for this perceived conduct that the trial court had under Tennessee, or the TCA 365103C. It gets back to who the prevailing party is. So I think what's important about that is that there were other tools that the trial court had to deal with this notion that there was some kind of inappropriate conduct by the appellant is. If he thought that he was not answering the discovery the appropriate way, is there's sanctions, there are motions to compel, there are motions for contempt to deal with that. If he thought that the appellant was being evasive in his answers at trial, the easy way to resolve that is not award him the relief that he was entitled to. And I think it's interesting is that the reduction of child support was never appealed. That's a final decision that the appellee agrees with. May not agree with it, but has accepted it. So I think it's important to sort of look at that is that there were only 2 litigants that testified at this particular hearing. And for the trial court to sort of assume that there was some inappropriate conduct by the appellant, but in the same vein, give him relief. He had to find him somewhat credible at that particular point is, because the easy answer would have been just deny him the relief, and I don't think we're here at that particular point. We're here because the court granted the relief that he sought. Again, may not have been as much as he requested, but it was certainly relief that he was entitled to. The next sort of portion of what the appellee seems to argue is that these fees are so intertwined that they cannot be separated. And we, of course, we disputed that in the brief. And I think in essence what the appellee is saying is that this $36,000 in attorney's fees that was incurred would have been the same thing for the motion for contempt. It would have been the same thing for the modification. So what our point of that is that this modification occurred 7 months prior to, the motion for, I apologize, the motion for the contempt. So it was 7 months before that, and so it can clearly be apportioned that particular way.
And so was that issue brought to the trial court's attention below that, hey, these fees are not reasonable because some of it relates to another component of litigation?
Yes, sir. We argued that was the whole purpose for the apportionment, was to argue that particular sort of different things. In fact, I think we even put a chart into the brief that indicates what we thought the reasonable fee should be. And our position on that was they could be separated. They could be identified as to what the differences of the fees were. I know they argued that was waived, but the trial court in its opinion indicated clearly that it didn't want to hear proof on the matter. So we were prepared to offer that as proof, and the court rejected that and didn't want to sort of hear that, but we had that proof available. In regard to the reasonableness of the fees, Our position is that you don't get to the reasonableness of the fees if the appellant is the prevailing party, and that's what we would submit to the court.
All right, thank you, Mr. Underwood.
Good morning, Your Honors.
Good morning.
Like the first appellee attorney, this is my first time before you all today. It's good to see you.
Well, I'm going to be nice again. So.
Thank you, Your Honor. My name is Courtney Lutz-Creel, and I represent the appellee in this matter, Rebecca Lynn Houston. Your Honors, this case is about father's willful and intentional failure to pay child support and misrepresentation and concealment of his income to unsuccessfully convince the trial court to make mother the child support obligor. As a result of mother being the substantially prevailing party on both the petition to modify and the petition for contempt, the trial court, and because of father's intentional concealment of his income, the trial court properly used its discretion to order father to pay mother's $35,000 in attorney's fees.
And counsel, it's your argument that your client prevailed on the modification petition because it did not go to zero. Is that the position?
Yes, Your Honor, and she was not made the child support obligor. The other reason for that, Your Honor, is because in father's petition to modify, which is in volume 1, page 1 through 4 of the record, father asked for his income to be assessed at $1,992.70. The court outright objected or rejected that argument, and instead, in volume 2 of page 266 of the record, set his income at $8,242. So about $500 less than what was under the original divorce decree. Yes, Your Honor. And although father filed a motion to apportion the fees, the trial court denied that request. And as it stated on page 264 of volume 2 of the record, it found such an apportionment to be, quote, patently inequitable. In turn, father has filed a frivolous appeal and is requesting relief from this court based on several arguments, including some that were made here today that were not made at the trial court level, are not in the record, and are not properly cited in his brief. And before I get to the core of the arguments, I would like to talk about the standard of review, because it seems as if father wants this court to analyze everything under a de novo analysis. But the standard of review today is abuse of discretion. And as the Tennessee Supreme Court has stated in Williams versus Baptist Memorial Hospital and Myant v. Allstate Insurance Company, this standard does not allow this court to substitute its judgment for that of the trial court. Rather, the court may only find an abuse of discretion if the trial court applied incorrect legal standards, reached an illogical conclusion, based its decision on a clearly erroneous assessment of the evidence, or employed reasoning that causes an injustice to the complaining party. And in this case, we're looking at an assessment of attorney's fees. That is an analysis under an abuse of discretion standard. And the trial court did not abuse its discretion in awarding mother her fees. Additionally, father wants this court to, it appears, to analyze the prevailing party analysis under an abuse of discretion standard. However, the case that appellant cited, Gorey versus UPS, in that case, the court was looking at the issue of apportionment. And in that case, the court did not apply a de novo standard to determine what is a prevailing party. Rather, the court again applied the abuse of discretion standard to say that we shouldn't be cherry picking different time entries in order to determine what an apportionment would be. If the trial court wanted to enter into that assessment, it certainly could have, but it didn't have to, and it decided not to in this case. As this court emphasized, in order to be a prevailing party, there must be a material alteration of the legal relationship of the parties, as the court pointed out the Kate Fannin v. City of La Follette, and that's where that standard is from.
We say La Follette in East Tennessee.
I'm sorry. I'm from Kentucky,
That's
so
right.
I'm trying to get the terms down.
You are still welcome here in the state of Tennessee.
I do know it's Milan. I do know Milan. I'm still working on that one. And then in Qualls v. Camp, which it was a case in front of this court, the court stated a relationship between the parties is materially altered by modifying the defendant's behavior in a way that directly benefits the plaintiff. And in this case, there was no material alteration of my client's behavior to alter Mr. Wilson's conduct. Rather, the only really substantial relief that Mr. Wilson received was to receive a slight reduction in his child support. And as we pointed out in our brief, one of the primary reasons for the modification of the child support amount was the fact that father had another child while this matter was pending. And that's on volume 3, page 23 of the record. And that was a huge part of that analysis. And we don't contest that.
Yeah, if we get past the analysis about prevailing party here, and agree with you that your client was a prevailing party.
Yes.
Did the trial court here cut short the proof on the reasonableness of the fees here? It seems like there was an effort made to try to challenge it, and the court just said, I'm not going to hear it. And we've got case law that says that if there's a request for evidentiary hearing, it should be held on the reasonableness of fees, give everybody an opportunity to argue that or submit evidence on that point.
Yes, Your Honor. So first of all, I would argue that Mr. Underwood could have certainly filed some sort of brief outlining what he believed the apportionment of fees should have been. He certainly could have done that on the initial phase. In volume 4 of the record, which is the transcript of that proceeding, Mr. Underwood said, I'm happy to present proof if the court wants to hear it. He kind of provided a lot of deference to the court regarding that issue. And the other thing I would emphasize is in volume 4, which is the transcript, the judge specifically asked Mr. Underwood, how much in fees do you believe that Ms. Creel should have been awarded? And his answer was, I don't know. And then when he was asked, well, how many hours should have Ms. Creel spent on this matter? His answer was, I don't know. So although Mr. Underwood is presenting to this court that he had certain information ready to provide, when asked those specific questions that are at the core of the apportionment issue, his answers were, I don't know. So I would argue that to the extent that is an issue, Mr. Underwood was not ready to provide that proof to the court that day. Additionally, Your Honor, to the extent that the court does not want to go into the prevailing party analysis, the issues of both petitions are so intertwined that mother's fees cannot be apportioned, and that goes back again to the Gorey case. I believe that Mr. Underwood has tried to differentiate that case by saying that the court was looking at plaintiff's issues only, and also that it was an employment case. But I believe that the case can also be applicable here. Just because the court was entering into an analysis regarding an employment issue, and just because the court was looking at plaintiff's issues before the court and which ones they were successful on, the court did not limit that analysis to an employment case or plaintiff's causes of action. Rather, the decision is primarily based on whether there is a common core of facts or legal theories. Here, the petition to modify was based on whether father's income had been modified. The same analysis is necessary for a petition for contempt. In other words, father's income and his ability to pay are a core issue in the petition for contempt. In this case, I sent father discovery requests. This is in the record. And when I asked father where he had bank accounts and where his bank accounts were located, he said he did not have any. Rather than send a deficiency letter because the answer was, I don't have any accounts, our office had to send out subpoenas to every single bank in Lincoln County to try to determine whether father was being truthful or not. And lo and behold, father had multiple accounts and multiple banks with $3.2 million flowing through them annually from what we analyzed. And based on that, we brought this before the trial court. Father stipulated to the admissibility of those bank records at the trial, and we were able to advise the court that Father was not being truthful about his 1992-70 income that he's trying to allege. And in fact, in the record, he says he didn't know what his income was. And we were also able to establish that Father had the ability to pay his child support. Obviously, he had the $535 he was awarded to pay, or ordered to pay, flowing through his accounts, and he just simply wasn't paying it. And so in both of those instances, the bank records were a significant part of determining that Father was not being credible in his testimony regarding his income, and also that he had the ability to pay his child support. So because the bank records played a vital role in both issues, they were necessary, and they were fees that were required to be incurred by our firm in order to demonstrate that Father was not being truthful, one, about his income, and two, about the fact that he had bank accounts. The third point, Your Honor, is that Mother's attorney's fees were reasonable. One thing that Mr. Underwood has brought up in his brief is that Mr. Kelly Wilson, who represented Mr. Clay Wilson, they're both Mr. Wilsons, only charged a $2,500 flat fee. And in Volume 4 of the record, which was the transcript of the proceeding on the motion for apportionment, Mr. Underwood said that Father got a heck of a deal, only having to pay $2,500 in a flat fee to Mr. Kelly Wilson for that trial. But beyond that, there was really no more analysis in comparing Mother's attorney's fees to Father's attorney's fees. All that Mr. Underwood alleged was that Mother should have received less than $35,000 in fees, but probably more than $2,500. Based on the arguments that were provided in my affidavit, which went through the Rule 1.5 factors, the court found that the fees were reasonable. The court found that the time and labor involved was significant, and the court actually put significant weight on this because of Father's lack of transparency in providing his income and bank account information. We needed that income information for both the petition to modify and to prove willfulness for contempt. The court emphasized that Mother sent Father discovery requests, and he said he had no bank accounts, and then it required Mother to go into this, what we considered a fact-finding mission, and how we explained that to the court. The court went through all of the other 1.5 factors and found that everything that we did was reasonable. I believe in Mr. Underwood's brief, although he did not bring this up in the trial court, he had an issue with the fact that we used an in-house CPA to analyze Father's bank accounts. But the court found and reviewed that analysis and found that to be a reasonable need because of the amount of money flowing through the accounts and to help us make those determinations for trial and how to bring them up at trial. A couple of other points that I wanted to address. Mother did not file a counter motion to modify. The reason for that is because our position at the trial, our primary position, was that Father could not meet the burden of proof to modify his child support. He had no expert there to testify, no accountant, which the court pointed out, to say that his income should have been modified or what it should have been modified to. But we provided an alternative argument, which is what Mr. Underwood brought up, which is that the court should consider all of these deposits flowing through his account. And if anything, his child support should be an upward deviation. Another thing I would point out is that Mr. Underwood emphasized that it would have resulted in a $184,000 a month child support amount, but as this court knows, there are statutory caps in Tennessee for child support, so at most it would have been $2,200. I'm running out of time, but I do want to bring up this last issue. We would ask for Mother's attorney's fees on appeal. Should this court determine that she is the prevailing party under 36-5103C, she is entitled to those fees. The other justification that we are asking for fees is that this is a frivolous appeal for two reasons. One, this court has previously described appeals that are based on the abuse of discretion standard. Those are the ones that are often considered frivolous. And then the other reason is because the majority of father's arguments, as we set forth in our brief, were waived on appeal because they were not made at the trial court level. And so we had to spend 8 pages of our brief pointing out those. And so again, we would ask that this court uphold the trial court's decision in awarding mother her $35,000 in fees. Thank you.
Thank you, Ms. Creel. Rebuttal?
Yes, Your Honor. In regard to the frivolous appeal, I think the appellant would say, I think this is a bona fide issue as to who the prevailing party is. We mentioned some of the things that they indicated, the appellee indicated that was waived. Part of that was the block of time entries that we said was appropriate for the motion for civil contempt or the petition for civil contempt. We did try to put that particular proof on there. I know what the response is when the court asked me what it was. The deference to the trial court is that's what you use evidence for. That's not necessarily an argument, but that's the reason that trial counsel Kelly Wilson.
Well, but it seems like here there was an opportunity to inform the trial court to say, wait a minute, let's not close just with arguments. I want to put on some proof, and that really didn't happen here.
Well, again, and maybe that's my deference to the trial court when the trial court says, I don't want to hear proof, I have the affidavits. I think that's what happens. It only makes sense that there would have been testimony is otherwise Kelly Wilson, trial counsel Kelly Wilson, would have been able to make the same arguments that I did. So there was a need to have a separate lawyer present to be able to make those
Well, was an
arguments.
offer of proof made here? There was not, was there?
There was not an offer of proof. The court simply said, I've got what I need and I'm prepared to do that. And if I deferred too much to the trial court, then that's certainly the case. But that's what the court said. The court said, I did not want to hear proof about it, and we indicated several times that we had highlighted sections of the time entries that indicated that it would be available.
The court seemed to make it pretty clear why it awarded the fees that it awarded in its memorandum. It said the reason that the attorney's fees requested are so high is father's lack of candor and his lack of compliance with discovery requests. Had father ever complied with discovery requests or actually shown his true income to anyone, this process would be significantly less difficult. The responsibility for the time and effort expended by mother is his alone, and he should bear the responsibility. The amount of time involved was exacerbated by the conduct of father, and this outweighs any lack of result obtained by mother.
And that goes to the apportionment, the findings of facts and conclusions of law for the apportionment. And this is the first time we were able to sort of argue different things about the conduct of the appellant. And what's confusing by that still is that the court could have ruled against him. He could have ruled against the father, saying you're not entitled to it because of the actions that you took. As Ms. Creel says, is that
Well, but to the trial court's credit, he looked past that and still made what the ruling that the law required.
And that gets back to 365103C that says is that you can only award attorney's fees to a prevailing party. And certainly I know that the court has asked me questions about that, about, well, is it enough that he didn't get everything that he wanted? Well, I think the Qualls opinion speaks to that, is saying that you have to have some kind of relief. And I wanted to clarify something that Ms. Creel said too. I wasn't suggesting that the child support was going to be $184,000. What they were arguing was his income was $184,000 per month, and what the court found was it was $100,000, less than $100,000 per year. So again, I think that's pretty significant in who the prevailing party was. You know, in regard to the Gorey case that was a case that was brought to the trial court's attention, and we weren't aware of that it wasn't briefed beforehand. So we briefed it here and I do think that is completely distinguishable than this particular case is. That is a situation where the Court of Appeals heard an employment issue where a plaintiff had multiple claims arising out of the same facts and circumstances, and some of those were prevailing issues, some of them were not. And the court said, we're not going to get into the minutia of the time entries, looking into seeing which one is appropriate and what's not. That is completely different than what this case is. We have competing motions. that are asking for different things by adverse parties. So I don't think there's any reliance on that. And again, I think there can be some untanglement of these particular sort of fees as we sort of outlined. Again, I don't think there's anything that's frivolous in this appeal, that if it was a question of who the prevailing party is, you still have to get to the reasonableness of the fees. And we would submit to you is that a party that receives a $20,000 reduction in its child support over the minority of the child, which is approximately 7 years, to have to pay $35,000 or more than $35,000 to be able to achieve that would have a chilling effect on someone that's entitled to a modification, bringing that before a court because of what the adverse consequences may be for legal fees.
All right, thank you,
Thank
Mr. Underwood and Ms. Creel, for your arguments. We'll take this matter under advisement.